Morning, ladies and gentlemen. Chief Justice of the Republic of South Africa, Chief Justice Mandisa Maya, the Speaker of the National Assembly, Ms. Togo Didiza, MP, Deputy Chairperson of the National Council of Provinces, Mr. Les Govender, MP, Deputy Chairperson of the National Assembly, Dr. Annelie Latreat, Deputy Chief Justice of the Republic of South Africa, Justice Dunstan Mlambo, President of the Supreme Court of Appeal, Justice Mahube Mulimela, Justices of the Constitutional Court, Justices of the Supreme Court of Appeal, Deputy Minister of Justice and Constitutional Development, Mr. Andries Nel, MP, Judges President, Deputy Judge President, and Judges of the High Court, members of the Portfolio Committee on Justice and Constitutional Development, members of the Select Committee on Security and Justice, other members of Parliament following these proceedings online, regional court presidents, chief magistrates, senior magistrates, and all other members of the judiciary following these proceedings on virtual platforms, members of the Judicial Service Commission, members of the Council of the South African Judicial Education Institute, members of the Audit and Risk Committee of the Office of the Chief Justice, members of Legal Fraternity, Acting Secretary General of the Office of the Chief Justice, Advocate Marlies Potgieter, and all officials of the Office of the Chief Justice, heads and representatives of the national departments, state institutions, and members of the National Efficiency Enhancement Committee, members of the public who are following these proceedings virtually via the various electronic platforms, members of the media. Ladies and gentlemen, my name is Dumisani Zondi, the Deputy President of the Supreme Court of Appeal, and I will be your program director for this 2025 Judiciary Day. It gives me great pleasure to speak to you this morning, to welcome you most cordially to the presentation of the annual judicial report for the 2023, 2024, and 2024-2025 financial years, a session we hold annually and have aptly named Judiciary Day. It is the first Judiciary Day to be hosted by the Chief Justice Mandisa Maya since assuming office in September last year. Today marks the 7th year of presenting the annual judiciary report in our efforts to be transparent and accountable for the responsibilities entrusted to the judiciary by the people of South Africa. Ladies and gentlemen, for those of you attending this session for the first time, I wish to assure you that we will not keep you for long, as our program is brief. Firstly, we'll receive the purpose of the Judiciary Day and the presentation of the annual judiciary report from the Deputy Chief Justice Mlambo. Following his remarks, we will receive our Honorable Chief Justice Mandisa Maya, who will give the keynote address and officially present the annual judiciary reports for the 2023-2024 and 2024-2025 financial years. We do not intend to make this session a monologue, but we want all our stakeholders present here to engage us on the report the Chief Justice will present on behalf of the judiciary. In this regard, after the Chief Justice keynote address, I will be facilitating the question and answer session. I need to stress here that this question and answer session will be for all stakeholders, excluding the media. Once the formal program concludes, the Chief Justice, together with members of the Judicial Accountability Committee, will host a media briefing where members of the media will be given an opportunity to engage them on the reports. The OCJ's communication personnel will direct the media accordingly in this regard. There's something that I just want to bring it to your attention. There will be a chat functionality. The chat functionality will be disabled, and the guest should introduce themselves before asking questions. And I will take the first 3 questions, and thereafter, then I may allow follow-up questions. We therefore appreciate our gratitude that you have availed yourself to join us today. Your participation suggests to us that you are committed to assisting and protecting the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness. We hope you'll find the day informative and enjoyable. Thank you for listening. Please welcome Deputy Chief Justice Mlambo to give us the purpose of the day. Over to you, Mapisa. Thank you.
Thank you, Manglinza. Honorable Chief Justice of the Republic of South Africa, Justice Mandisa Muriel Maya, Speaker of the National Assembly, Ms. Togo Didiza MP, President of the Supreme Court of Appeal, Justice Mahube Mulimela, Deputy Chairperson of the National Council of Provinces, Mr. Les Govender MP, Deputy Chairperson of the National Assembly, Dr. Annelie Lottrit, colleague judges, colleague magistrates, Honorable Chief Justice, please allow me to adopt all the protocols that have been observed by Manglinza. Ladies and gentlemen, fellow South Africans, today we, led by the Chief Justice as the South African judiciary, present the 6th and 7th annual judicial reports covering the 2023-2024 and 2024-2025 financial years. The annual judicial report was inaugurated in November 2018, and since then, this practice has become a cornerstone of how the judiciary accounts to the public. Still, it remains prudent to remind everyone, I think, why we undertake this exercise. The basis of the production of an annual judicial report is grounded in our constitutional order. Section 165 provides that The judiciary is independent and subject only to the Constitution and the law. In keeping with this constitutional injunction and the principle that judicial independence is inextricably linked to judicial accountability, it follows that we are required to account directly to the nation on the responsibilities we have been entrusted with. The guarantee of judicial independence is not a shield from scrutiny. Indeed, accountability arises from independence and is ensured through institutional structures which provide for transparent reporting, performance measurement, and maintaining public trust. Notably, we are not the only judiciary that has adopted this model of publicly reporting on our work. Several other jurisdictions have embraced similar approaches as part of strengthening transparency and public trust. Section 165 of our Constitution designates the Chief Justice as head of the judiciary responsible for establishing and monitoring norms and standards for judicial functions in all courts. These norms and standards, adopted with the support of the heads of courts, give expression to values such as access to justice, dignity, efficiency, and expeditious adjudication. In the context of judiciary reporting, these norms and standards provide the framework against which judicial performance is measured and reported. They establish clear benchmarks and expectations, enabling the judiciary to assess whether courts are meeting their constitutional mandate. Reporting in line with these norms and standards ensures that the judiciary's accountability is grounded in objectively verifiable criteria. Through our annual public reporting, we therefore fulfill a constitutional duty. We account to the public on how we serve, the challenges we face, and how we can improve. This mechanism of accountability is not a mere formality. It is embedded into the function of the judicial system. Since the inaugural annual judicial report in 2018, the reporting process has developed. The initial report laid institutional foundation by outlining the roles of the Chief Justice, the norms and standards, and the Judicial Service Commission, while presenting data on court performance and case flow. Subsequently, the report incorporated key performance indicators aligned with the annual judiciary performance plan, enabling systematic tracking of objectives such as case flow management and finalization rates. More recently, the report has addressed operational challenges, including infrastructure limitations and the impact of load shedding, while also highlighting advancements in digital modernization and expanded judicial education initiatives. The reports have gradually provided more insight into the judiciary's challenges and priorities, continuing to evolve as an instrument of judicial accountability. As our public engagement continues to develop, I take this opportunity to remind our stakeholders present online that this is an interactive session, as Manginza said. I wish to express on behalf of the judiciary our most sincere wish that the engagements from the interactive session will positively contribute to enhancing independence, impartiality, dignity, accessibility, and effectiveness of the courts. We gather today to account and to engage with you and reflect in a spirit of accountability and transparency. The annual judicial reports that the Honorable Chief Justice will present today provide an overview of the performance of the courts. We trust that the 2023-2024, 2024-2025 annual judicial reports will be well received by the South African publics. Thank you very much. I thank you, CJ.
Thank you very much, Mapisa. Now, I just want to call upon the Chief Justice of the Republic of South Africa, Justice Mandisa Maya, to deliver a keynote address for us. Thank you very much, Chief Justice.
Thank you very much. I will follow my lieutenant's example and call you Manqinza. I didn't know your clan name until now. Thank you, Program Director, Deputy President Zondi. The Program Director and the Deputy Chief Justice have already acknowledged everyone following these proceedings, so I will seek the indulgence to stand on the protocol they have established in the interest of time. DP, please allow me to acknowledge you as our guide during these proceedings. The Speaker of the National Assembly, Ms. Togo Didiza, MP, the Deputy Chief Justice of the Republic of South Africa, Justice Mlambo, all the representatives of the other arms of government, our stakeholders, and most importantly, fellow South Africans. Good morning. We gather on this Judiciary Day to mark an important moment of accountability, transparency, and acknowledgement of the rule of law in our democracy. Judiciary Day is a unique occasion during which the South African judiciary accounts to the nation on the performance of its judicial functions. Our Constitution affirms the independence of the courts, which must apply the law impartially and without fear or favor. While many state organs are constitutionally required to account to Parliament, the judiciary's accountability is to you, the public. This is expressed through Judiciary Day and our annual judiciary reports. These reports, presented each year, provide a clear and honest reflection of the challenges, achievements, and ongoing efforts within our courts. The significance of Judiciary Day lies in its affirmation of the judiciary's unwavering commitment to uphold justice without prejudice and to maintain the highest standards in the administration of justice. It is a day that embodies our duty to remain open, accountable, and responsive to you, the people we serve. Through this day, we reinforce that the judiciary stands as an independent guardian of the Constitution, accountable to the law and the citizenry. This culture of openness and reporting is testament to our collective dedication to strengthen trust in the judicial system and to ensure that justice is accessible, fair, and effective for all. This Judiciary Day, as we take stock of the state of South Africa's judiciary, is a big milestone for me as I present to my country for the first time as Chief Justice the annual judiciary reports for the 2023-2024 and 2024-2025 financial years. The scope of the annual judiciary reports that I'm presenting today, as is customary for these instruments, covers only the following matters within the judiciary's performance of its judicial functions. 1, court performance of the superior and magistrates courts. 2, judicial education and training. And 3, judicial appointments and retirement. I will then deal with other features that influence the performance of the judiciary, which do not fall within the scope of the reports, but are nevertheless important. For now, it is appropriate to share with you some of the important information in the reports concerning the judiciary's performance of its judicial functions. The Judicial Accountability Committee, comprising heads of court and led by our Deputy Chief Justice, plays a pivotal role in strengthening judicial performance, ensuring that justice delivery is both effective and transparent. The annual Judiciary Performance Plan and its associated monitoring report serve as essential instruments to track progress against predefined targets, giving us a clear picture of how the courts perform. The purpose of court performance monitoring and reporting is to provide progressive updates on the implementation of the annual Judiciary Performance Plan with specific reference to monitoring delivery against set quarterly performance targets. The annual Judiciary Performance Plan, in turn, defines and identifies performance indicators and targets for the various courts. These performance indicators and targets are measures that allow for the monitoring of the performance on one or more aspects of the overall functions and mandate of the judiciary. Importantly, the annual Judiciary Performance Plan indicators for the judiciary, as reflected in the annual Judiciary Report 2020-2021, remain relevant for the two reporting periods under review. Overall, the judiciary had 14 performance targets for the consecutive periods. It is heartening that a comparative analysis of the Superior Court's performance over the past 2 financial years shows considerable judicial activity over the period, with notable progress in several areas, alongside, of course, the persistent challenges which require sustained focus. In the 2023-2024 financial year, the Superior Courts achieved 8 of the 14 key performance targets, representing a 57% overall achievement rate. The Constitutional Court finalized 66% of the cases on its roll, falling short of the 70% target. The Supreme Court of Appeal completed 74% of its case roll, some points below its 80% goal, while applications for leave to appeal, on the other hand, were finalized at 93%, thus exceeding the 80% target. The Labour Appeal Court finalized 77% of its enrolled matters, just a margin under its 80% target, but surpassed the target of 90% in respect of applications for leave to appeal by achieving a 99% finalization rate. The High Court divisions finalized 66% of the enrolled criminal cases, well below the 75% target, but they far exceeded the target in respect of mental health applications and civil cases by achieving finalization rates of 98% against a 90% and 87% against a 64% target, respectively. Notably, criminal case backlogs were reduced by 45%, still 15 points above the 30% target, but marked improvement shown in the management of judicial efficiency despite other setbacks. The Labour Court and Land Claims Court also exceeded their targets at 60% against 58%, a 58% target, and 69% against a 60% target, respectively. The Competition Appeal Court and Electoral Court performed strongly, finalizing 100% cases against an 85% target and 93% cases against a target of 90%, respectively. Reserve judgments in all the high courts were finalized at 69%, just shy of the 70% target. Transitioning into the 2024-2025 financial year, the overall court performance showed improvement, with 9 of 14 targets achieved at 64%. The Constitutional Court slightly exceeded its target of 70% by finalizing 71% of its enrolled cases. The Supreme Court of Appeal excelled in its management of applications for leave to appeal by finalizing 97% against the 80% benchmark. But the percentage of appeals it finalized dropped to 72%, below its target of 80%. And it attributes this drop mainly to external factors such as counsel's availability, requests for postponements, requests to supplement papers, and join parties. The High Court divisions continued their solid performance in respect of mental health applications by finalizing 97% against the targeted 90% benchmark and 88% of civil cases against the targeted 64% finalization rate. Notably, criminal case backlog reductions improved further, well, slightly marginal from the previous year, but an improvement nonetheless to 43%, 2 points lower than in the 2023-2024 financial year. Though still below ideal targets in some jurisdictions such as KwaZulu-Natal, Mpumalanga, Eastern Cape, Western Cape, Free State, and Gauteng, the Electoral Court maintained perfect case finalization rates, thus excelling in its critical role of dispensing electoral justice. And that is kudos to the Deputy President of the Supreme Court of Appeal, Justice Zondi. Well done. Challenges recurred, and the Labour Courts and the Competition Appeal Court also fell short of their targets, with the Labour Appeal Court finalizing 71% of its matters as opposed to the targeted 80%. The Labour Courts finalizing 55% of their matters as opposed to the targeted 58%, and the Competition Appeal Court finalizing 77% of its case roll as opposed to the 85% target. 10 of the 14 annual judiciary performance plan indicator targets were met in this financial year, that is 2024-2025. The finalization of 71% of the constitutional court case roll, which translates in real terms to 387 matters out of a total of 544 matters. The applications for leave to appeal at the Supreme Court of Appeal and the Labour Appeal Court exceeded the targets. But the national target for the reduction of criminal backlogs and finalization of criminal matters at the High Courts was not met. The reported reasons, well, some of the reported reasons for this being that cases involved multiple accused, the trials were lengthy, the matters were complex. Although the reserve judgment target was met, especially by the appeal courts, there was a low finalization rate at the Constitutional Court. And that unfortunately persists because of the structural challenges in the court. For example, as at 1 November 2025, I'm jumping to this financial year just to illustrate the point, judgment in 13 matters had been reserved for longer than 6 months, 5 of them from 2024. And these are the matters of Godloza, which was reserved in March 2024 and delivered on 5 November 2025, Municipal Employees Pension Fund versus City of Johannesburg Metropolitan Municipality, which was reserved on 19 November 2024 and was delivered on 21 October 2025. Reynolds Malega versus Timothy Boiseno, which was reserved on 12 September 2024, remains reserved. Golden Core versus Merafong Municipality, reserved on 7 November 2024, remains reserved. And EFF versus Speaker of National Assembly and others, reserved on 26 November 2024 and remains reserved. The main reasons for the non-achievement of reserve judgment targets, especially in the Apex Court, are that the Apex Court's schedule is significantly impacted by a heavy flow of high-profile, complex, and urgent matters that fall within its exclusive jurisdiction or ambit of direct access. These cases demand the intense attention of all the justices who sit and bank, and as the apex court and final arbiter, the matters enrolled in the court typically involve extensive records, including numerous sets of pleadings and written submissions, and a multitude of parties, resulting in a substantially greater volume of reading and preparation compared to other courts. As the court continues to break new ground by addressing novel and intricate legal questions of law at the cutting edge of constitutional law, demanding careful reflection, refined legal writing, extensive research, and a consideration of the law beyond the Republic's borders. But moves are afoot to moves, including a constitutional amendment, afoot to capacitate the court in the near future, as moves afoot to capacitate the rest of the courts in the country. Needless to say, the timely delivery of judgments is a priority for every judge and every court, including the Constitutional Court. The judiciary is acutely aware that judgments are not always delivered within the prescribed time, and that when this occurs, it unfortunately results in uncertainty in the law, and any resultant impatience by litigants and interest groups is fully understandable. But we can assure everyone concerned that every effort is being made to deliver all outstanding judgments expeditiously. To sum up, over the 2 financial years under review, the superior courts have demonstrated commendable progress in handling applications, mental health, civil, and electoral matters, which contributes positively to strengthening the rule of law and engendering public trust. Yet, underperformance in criminal case and appeals finalization, backlog management, and reserve judgment delivery, as I have pointed out, persists as critical areas needing targeted interventions. But it is not all hopeless. Despite these challenges, in the 2023-2024 financial year, the total number of reserve judgments delivered by all superior courts increased by 32% from 5,368 matters during 2022 to 2023 to 7,062 during 2023-2024. The total number of judgments delivered within 3 months by all the superior courts during this period increased by 27% from 3,853 matters to 4,880 matters. The figures continue to improve into the 2024-2025 financial year, as the total number of reserve judgments delivered by all the superior courts increased by 8% from 7,062 matters during 2023-2024 to 7,611 during 2024-2025, and those delivered within 3 months increased by 12% from 4,880 during 2023-2024 to 5,441 matters during 2024-2025. And I mention these numbers just to illustrate the workload that is borne by the courts. I mean, these thousands of matters that are heard in a short space of time by judges in the case of the superior courts, who are no more than 250. What is critical to point out, however, is that sustained advancements and efficient, effective administration of justice depends on robust institutional support, meaningful resource allocation, adequate judicial appointments, a safe working environment for all judicial officers, and, of course, continuous monitoring through bodies such as the Judicial Accountability Committee of the Heads of Court Cluster, who I have to laud for their tireless work in keeping a close eye on court systems and operations to ensure that the judiciary is equipped with the necessary tools and is working. These measures are crucial to ensure that South Africa's courts all the courts not only meet but exceed performance expectations, thereby strengthening the foundation of our constitutional democracy. I now turn to the performance of the Magistrates' Court and start with the regional courts, which play a crucial role in our justice system, handling serious criminal matters such as murder, rape, robbery with aggravating circumstances, trafficking in persons, and serious commercial crimes, with the competency to impose life imprisonment and a maximum fine of 600,000 rand. These courts also exercise civil jurisdiction on important family law issues, including divorces and interim custody, and civil cases involving monetary claims ranging from 200,000 to 400,000 rand. The regional courts demonstrated active judicial performance during the 2023-2024 financial year, utilizing a total of 67,705 court days and 207,770 hours. They registered 41,420 new criminal cases and disposed of 40,709 cases, achieving an average court hour time of 3 hours and 4 minutes a day, below the 4 hours, 30 minutes standard. The clearance rate was excellent at 98%, with trials enrolled at 2.42 per day and trials finalized at a rate of 0.29 cases per day. Throughput per case averaged 10 hours and 31 minutes. Compared to the previous year, criminal court days rose by 4%, new cases increased by 11%, and court hours increased by 10%, while disposed cases slightly decreased by 1%. Civil court performance took 13,939 court days and almost 28,033 hours. Civil case finalization rates totaled 55% for applications and 60% for trials, with average court hours of 2 hours, also below the normal 4 hours, 30 minutes. Enrolled applications and trials per day averaged 1.04 and 2.12, respectively. Year-on-year civil court days and enrolled cases showed modest increases, 3% and 2%, while finalized cases remained unchanged. Key case flow blockages impacted court efficiency, mainly arising from the Department of Justice and Constitutional Development, which accounts for 19% of those, Legal Aid South Africa, which accounts for 14% of those blockages, prosecution services accounting for 13%, private practitioners 13%. Challenges included court infrastructure issues, equipment faults, stakeholder unavailability, load shedding, adverse weather, and natural disasters. Judgments were generally handed down within the prescribed 3-month norm, with no prolonged reservation periods identified. Overall, the regional courts displayed commitment to transparency and judicial accountability, with ongoing efforts to monitor performance and address blockages, aiming to reduce trial delays and avoid lengthy incarcerations while awaiting trial. During the 2024-2025 period, the regional courts utilized 65,461 court days and 204,327 court hours. They registered 41,512 new criminal cases and disposed of 40,072 cases. The courts achieved a 97% clearance rate with an average of 3 hours, 7 minutes per court session, which remains below the normal 4 hours, 30 minutes. Cases were enrolled at 2.43 per day and finalized at 0.3 per day, with an average throughput of 10 hours, 17 minutes per case. Compared to the 2023-2024 financial year, court days decreased by 3%, finalized cases fell by 2%, court hours declined by 2%, and new cases remained constant. Regional variations reveal that the Northern Cape maintained an exceptional finalization rate of 148%, while Limpopo had a lower clearance rate at 55%. Gauteng and Western Cape also performed above 100% clearance rates. In civil court matters, the courts used 12,926 court days and approximately 26,907 hours, with 24,035 applications enrolled and 13,351 finalized. Civil court performance showed 56% of applications and 60% of trials finalized, with average court hours of 2 hours, 4 minutes. Year-on-year comparison showed a 7% decrease, a 6% in court days, a 6% decrease in finalized cases, and a 4% reduction in court hours. Key factors causing case flow blockages included prosecution services, Legal Aid South Africa, private practitioners, accused persons, and witnesses. Challenges involved infrastructure issues, stakeholder unavailability, equipment defects, load shedding, and adverse weather conditions. Judgments were generally rendered within the required 3-month period following hearings, with no significant delays reported. The dedicated judicial officers of the regional courts remain steadfast in accountability to the public. Efforts to monitor court performance rigorously, alongside proactive measures to address case flow blockages, are central to continued progress. And I turn to the district courts, which are equally vital to our justice delivery system, handling a broad range of criminal cases, with the exception, of course, of the most serious offenses such as attempted murder, treason, rape, and terrorism. But in addition to criminal jurisdiction, the district courts have exclusive authority over preliminary inquiries under the Child Justice Act and handle civil matters of up to 200,000 rand, as well as crucial family law issues such as protection orders, children's courts, and maintenance matters. During the 2023-2024 financial year, the district courts grappled with ongoing ICT challenges affecting data capturing and court management systems, with criminal case statistics left, unfortunately, to the magistrate's monthly returns rather than the integrated case management system for collation and capturing. This led to limitations in reflecting through judicial performance. But despite these challenges, the courts maintained strong performance indicators. Key performance highlights included an average of 95% of criminal cases finalized across all administrative regions, with significant caseloads handled, such as 725,000 cases in Gauteng and Johannesburg alone, thus achieving a 97% finalization rate. And that's just one example. Child justice preliminary inquiries, which are critical for protecting children in conflict with the law, were finalized within 30 days at an average rate of 84%. Cape Town, Durban, and Pietermaritzburg regions showed particularly high compliance, exceeding 90%. Maintenance matters were finalized within 90 days at an average rate of 89%, reflecting a commitment to efficiently resolving family maintenance issues. The Eastern Cape B Mthatha region led with a 95% finalization rate. Challenges impacting case flow included deficiencies in court recording systems, language interpretation services, essential court infrastructure, and persistent load shedding, all affecting case finalization rates and court operations. The Department of Justice and Constitutional Development has committed to upgrading court ICT infrastructure, whose responsibility is theirs, by rolling out fiber optic connections and developing improved data capture tools in consultation, of course, with judicial officers. Additionally, supervision and same-day data entry initiatives aim to enhance the accuracy and timelines of statistics, enabling judicial officers to monitor performance more closely. The district efficiency and enhancement committees and provincial efficiency and enhancement committees have been working to strengthen stakeholder cooperation to overcome systemic blockages and improve overall court efficiency. Owing to the ongoing ICT challenges within the Department of Justice, which I've mentioned, during 2024-2025, criminal case data in the district courts continue to be sourced from the magistrates' monthly judicial returns, what is called an MC15 tool, which unfortunately does not fully reflect judicial performance according to norms and standards. Challenges with capturing data for domestic violence and children's courts remain to date. Nevertheless, data on child justice preliminary inquiries and maintenance matters covering 240 courts was audited and found reliable, with the department receiving an unqualified audit opinion for the year. Key performance highlights for 2024-2025 include a strong average criminal case finalization rate of 94% across all administrative regions, with the highest caseload in Gauteng, Pretoria to be precise, disposing of 721,615 cases at 97% finalization. Child justice preliminary inquiries were finalized within 30 days at an average of 84%, demonstrating priority towards protecting vulnerable children. Durban and Pietermaritzburg achieved the highest rates at 95%, but Johannesburg lagged behind at 61%. Maintenance matters were finalized within 90 days at 89% on average, reflecting the commitment to expeditiously resolve matters protecting children's interests, with Mthatha leading again at 91%. Operational challenges impacting court efficiency included insufficient court recording systems, language interpretation support, laptops, printers, and the effects of persistent power and water outages on court functionality, which plagues most courts across the country, including the Apex Court itself. The Department of Justice and Constitutional Development committed to rolling out fiber optic connections to all the courts to improve ICT stability, and plans to implement a new data capturing tool developed in consultation with district court judicial officers. An improvement plan mandates daily data capture by supervisors and data capturers, supported by monthly reporting to empower judicial officers to ensure data accuracy through regular oversight. But despite these ICT and infrastructural challenges, the district courts maintained solid finalization rates and remain focused on providing timely access to justice through continuous performance monitoring and enhanced stakeholder collaboration. I turn to judicial education and training, which are indispensable tools to maintaining a judiciary that is independent, impartial, dignified, accessible, and effective. Continuous professional development equips judicial officers with the necessary knowledge and skills to interpret and apply the law in an evolving legal landscape, ensuring that justice is served fairly and efficiently. The South African Judicial Education Institute, SAJE, which was established by the Judicial Education Institute Act of 2008, fulfills this vital role. Since commencing training in 2012, SAJE has been guided by a council comprising senior judicial officers, including the Chief Justice, legal professionals, academics, and representatives from the executive and traditional leadership. This diverse body ensures that judicial education reflects the values and needs of our constitutional democracy while embracing innovation and inclusivity. SAJ's primary functions include developing and providing continuous education and professional training for serving and aspirant judicial officers, conducting research to improve judicial education, and promoting the quality and efficiency of justice delivery. SAJ continues to deliver training for aspiring judicial officers at all 3 levels of the judiciary, in line with Section 5B of the SAJ Act. The aims of the programs is to contribute towards a pool of candidates eligible for appointment to the bench. Of particular note is SAJ's commitment to advancing gender transformation through the Aspirant Women Judges Program. The program is a flagship initiative that deserves special commendation for its vital role in addressing gender imbalance within South Africa's judiciary. The program cultivates a capable pool of women ready to take up high court vacancies, with 100% of its graduates currently acting in these courts. Launched in August 2007 and recently renamed in honor of Ambassador Bridget Mabandla, former Minister of Justice, who, in collaboration with the South African chapter of the International Association of Women Judges, conceived this brilliant initiative. The program offers intensive training, mentorship, and practical exposure to highly qualified women magistrates and legal practitioners with at least 12 years of experience. Many of the original graduates have since risen to prominent judicial positions, with some now serving as senior judges, including at the Supreme Court of Appeal. This highlights the program's success in equipping women with the skills, knowledge, and confidence necessary to serve at the highest levels of the judiciary. SAJ's dedicated efforts through this program are pivotal not only for the promotion of gender equality, but also for enhancing the representation, legitimacy, and effectiveness of the South African judicial system. SAJ is mindful of the financial constraints for legal practitioners participating in the program and has actively sought funding to provide a stipend to this cohort during the attendance of the compulsory training, often with difficulty, unfortunately. During the 2023-2024 financial year, 12 aspirant women judges graduated from the program. SAJ is currently in receipt of 104 applications for the upcoming group. In the periods under review, SAJ delivered 122 judicial education courses, exceeding its target of 115. The curriculum has been aligned with contemporary legal developments, providing training on pressing issues such as illegal wildlife trafficking, climate change, artificial intelligence, and the use of ChatGPT. Online courses, especially targeted at district court magistrates, have expanded access and enriched judicial understanding of complex and emerging topics. SAJ also serves an important continental role, among others, supporting the Africa Electoral Justice Network by hosting webinars that build capacity for electoral justice and the preparation for elections, thus bolstering democratic processes across the continent, the African continent. Despite a slight decrease in participant numbers due to connectivity issues caused by load shedding, over 3,700 delegates attended SAJ training sessions in both periods under review, including newly appointed judges, magistrates at various levels, aspirant judges, and even foreign judicial officers. SAJ has published the 6th edition of the journal, which has been accredited by the Department of Higher Education and Training since 2023. The journal promotes scholarly contributions from the judiciary, legal professionals, and academics. Through publications and training, SAJ has cultivated a culture of continuous professional development. And it recently published a book of essays authored by judges, has made a significant contribution to judicial education by providing critical insights, research, and reflections on contemporary judicial challenges and transformation. This publication not only enriches the knowledge base of judicial officers, but also fosters dialogue and learning essential for the evolution of a more effective and inclusive judiciary. Complementing its educational initiatives, SAJE has been given the crucial responsibility of training judges and magistrates on the newly adopted sexual harassment policy of the South African judiciary. This training will play an instrumental role in shaping a judiciary that upholds dignity, equality, and accountability, addressing systemic issues of misconduct and fostering a culture of respect and safety within the court environment. Together, these efforts underscore SAJE's pivotal role in strengthening the quality, integrity, and transformation of the South African judicial system. The Institute's continuing efforts ensure that our judiciary remains competent, responsive, and equipped to meet the challenges of modern justice administration for all South Africans. On judicial appointments and retirements, following the judiciary's commitment to robust judicial education and continuous professional development, it is as important to consider the critical processes of judicial appointments and retirements. These processes ensure that our courts are staffed with competent, diverse, and dedicated individuals who uphold the integrity and independence of the judiciary, thereby sustaining the constitutional promise of justice for all. In terms of Section 174, subsection 6 of the Constitution, the President appoints judges of all superior courts based on the advice of the Judicial Service Commission, the JSC. The JSC is a constitutional body established in terms of Section 178 of the Constitution, tasked with this responsibility, and its primary functions are to interview candidates for appointment as judges and advise the President as to which candidates to appoint as judges, or in the case of judges of the Constitutional Court, to provide the President with a list of candidates from whom the President will make appointments. The other function is dealing with certain complaints against judges through the Judicial Conduct Committee, the JCC, or Judicial Conduct Tribunal, JCT, which are established in terms of the Judicial Service Commission Act. The Commission deals with matters referred to it by the JCC and also with others that are referred to it by the JCT. And JSC also advises national government on any matter relating to the judiciary or the administration of justice, but when it considers any matter except the appointment of a judge, this distinction is important. It must sit without the members designated in terms of Section 178, 1H and I of the Constitution. During the 2 periods under review, the JSC met on 5 occasions. These sittings were convened as part of the Commission's biannual sittings to receive a briefing from both the Chief Justice and the Minister of Justice and Constitutional Development about matters that affect the courts, to address issues that affect the judiciary, and to interview and recommend candidates for vacancies that arose in the various superior courts. During the 2023-2024 financial year, 35 vacancies arose in the superior courts. The Commission interviewed candidates and advised the President to appoint 24 of them, all of whom were subsequently appointed. In the 2024-2025 financial year, 33 vacancies arose in the superior courts. The Commission interviewed candidates and advised the President to appoint 27 individuals, all of whom were subsequently appointed. Significant appointments in the 2023-2024 financial year included Justice Mulemela as the President of the Supreme Court of Appeal, to fill a vacancy that arose upon my appointment as the Deputy Chief Justice. In the 2024-2025 period, I was appointed Chief Justice, and Justice Zondi was appointed as the Deputy President of the Supreme Court of Appeal, both positions effective from 1 September 2024. In 2023-2024, the gender composition of newly appointed judges comprised 14 females, representing 56%, and 11 males, representing 44% of that group. The gender and racial composition of the judiciary is finally undergoing positive and discernible transformation. Of the 29 judges appointed in 2024-2025, 14 were women, and that totals up to 48%, and 15 were men, which amounts to 52%. On the issue of race, the judiciary comprises 49% African judges, 31% white judges, 11% colored judges, and 9% Indian judges, with a gender balance close to parity, 51% males and 49% females across superior courts, in some courts with the women judges in the majority. Notably, President Mulemela's court, the Supreme Court of Appeal, stands out as a beacon of gender transformation within South Africa's judiciary, with a majority of its judges, that is 13 out of 23, 56%, being women, a remarkable achievement that underscores the progress towards greater inclusivity at the highest appellate level. The Constitutional Court, South Africa's apex court, comprises a diverse bench that includes 4 women justices, colored woman justice, and 3 African women justices. Of the 9 permanently occupied positions, 1 white male justice, an Indian male justice, a colored male justice, and 2 African male justices. These demographics reflect a commitment to representation and equality. In terms of judicial leadership, women hold significant positions across the judiciary, starting with the Chief Justice, who leads the entire judiciary and the Constitutional Court for the first time in the history of this country, the President of the Supreme Court of Appeal, the Judges President of KwaZulu-Natal, Mpumalanga, and Western Cape divisions of the High Court, 3 women out of 9 judges President in the 9 provincial divisions of the High Court, and 5 women Deputy Judges President in the 9 High Court divisions. One of the 4 specialized courts, the Land Court, is led by women in both the Judge President and Deputy Judge President positions. Women occupy 6 of the 9 positions of regional court presidents and 15 out of 19 chief magistrates in multiple stations across the country. Collectively, these leadership demographics signify meaningful strides towards a judiciary that mirrors the nation's demographic composition and advances gender equality at each of its tiers. Notably, divisions of the High Court have achieved or exceeded 50% female representation, reflecting ongoing progress in gender transformation. During the 2023-2024 financial year in the Magistrates Court, a total of 48 magistrates were appointed, of which 52%, that is 25 out of 48, were black females, 25%, 12 out of 48, were black males, 8%, 4 of 48 were white females, and 15%, 7 of 48 were white males. The race and gender composition of the Magistrates Court establishment is made up of 23% African females, that is 336 out of 1,475, 25% African males, that is 366 of the 1,475, 13% white females, 196 of the 1,475, and 13% white males, 190. During the 2024-2025 financial years, a total of 227 magistrates were appointed, of which 28%, 64 of 227 were African males, 32%, that is 72 of that number, were African females, 3%, 7 of that number were Indian males, 7%, 15 of that number were Indian females, 4%, 8 of that number were colored males, 8%, 19 of the number were colored females, 7%, 16 of the number were white males, and 11%, that is 26 of the 227 were white females. The race and gender composition of the Magistrates Court establishment is made up of 28% African females, 23% of African males, 12% of white females, and 11% white males. Retirements, the other side of the coin, also marked this reporting period, with several judges and magistrates discharged from active service, including judges at the Supreme Court of Appeal, various high courts, and the Labor Court. These transitions create opportunities to infuse fresh talent and perspective into the judiciary and help it to sustain its dynamism and responsiveness. But there is also a downside when this happens en masse. While retirements mark an inevitable and natural transition within the judiciary, some divisions have unfortunately experienced a significant loss of institutional memory and senior expertise. The KwaZulu-Natal division, for example, following the Supreme Court of Appeal, have seen the retirement of a number of senior judges in quick succession, creating a sizable gap in critical areas such as commercial law. This presents a challenge in maintaining judicial continuity and underscores the urgency of consistently building a strong pool of competent candidates from which judicial appointments can be made as and when the need arises. Such as training and mentoring programs are therefore indispensable as they play a critical role in equipping aspirant judges with the skills and knowledge necessary to fill these voids and ensure the sustained quality and stability of the judiciary. The continuous cycle of appointments and retirements, when coupled with dedicated judicial education, strengthens the judiciary's capacity to uphold constitutional values, administer justice fairly, and maintain public confidence in our courts. It is our collective responsibility to ensure that the process remains transparent, merit-based, and aligned with our national imperatives of diversity, transformation, and excellence. Regarding the Judicial Service Commission related matters which were covered in the JS's annual report submitted to Parliament, it's not part of the two reports before us, but I will cover it nonetheless. As I have mentioned earlier, one of the JS's primary responsibilities is adjudicating certain complaints against judges through the Judicial Conduct Committee and the Judicial Conduct Tribunals established in terms of the Judicial Service Commission Act. The Judicial Conduct Committee consists of the Chief Justice, the Deputy Chief Justice, and 4 other judges, 2 of whom must be women, as contemplated in Section 8 of the JSC Act. An overview of the complaints received over the past 3 years shows that there has been a significant, a tremendous increase of complaints each year. For the reporting period 2022-2023 financial year, 93 complaints against judges were received. Of these, 72, that is 77%, were resolved, and 21, which translates to 23%, were carried over to the 2023-2024 financial year. Of the 21, 14, that is 67%, were resolved in the 2023-2024 financial year, and 7, which accounts for 33%, were carried over to the 2024-2025 financial year. Of that 7, none were resolved in the period under review, and they remain pending during this current financial year. For the previous reporting period, namely the 2023-2024 financial year, 125 complaints, a significant rise from the previous year, were received. Of these, 70, that is 56%, were resolved, and 55, which is 44%, were carried over to the 2024-2025 financial year. Of that 55, 6, that is 11% of the complaints were resolved, and 49, which is 89%, were carried over to the current financial year. For the 2024-2025 financial year, number increased. 132 complaints were received, and 38, that is 29% of those complaints were resolved, while 94, which is 71%, remained pending at the end of the year and were carried forward to this current year. The backlog in the complaints process can be attributed to many factors, such as the challenges faced by the Judicial Conduct Committee in its composition. And I hasten to mention that efforts have been made to increase the number of judges from 5 judges, who most of them are sitting judges and have other workload. Well, the Chief Justice and the Deputy Chief Justice, as I mentioned, are involved there, and they have their own workloads to contend with. So an effort has been made to increase the number of judges who serve in the Judicial Conduct Committee by proposing an amendment to the Judicial Service Commission Act. And that process is going on quite well. The Judicial Amendment Bill, which encapsulates the proposed amendments, is before Parliament as we speak. So hopefully that act will be promulgated soon, and the component of the court the JCC, the committee, can be increased. Furthermore, the Judicial Service Commission Act states that when a complaint is lodged, the chairperson must deal with the complaint in terms of sections 15, 16, or 17 of the Judicial Service Commission Act. This has put a lot of pressure on the chairperson, who is the Chief Justice, or in this case, the Deputy Chief Justice, where the chairperson has delegated his or her powers or functions as chairperson to them. The challenges faced by the chairperson or acting chairperson are that, as I've mentioned, they are sitting judges of the Constitutional Court and head the judiciary, as well as many other committees, resulting in a lot of work that is bestowed on them as members of the Judicial Conduct Committee. So the Judicial Conduct Committee has made further proposals in view of amending the JSC Act in order to resolve this issue as well going forward. The lack of resources in the administrative support to the Judicial Conduct Committee has also contributed immensely to the slow pace of dealing with complaints against judges, although the OCJ has made strides in ensuring that the Secretariat of the Judicial Service Commission is capacitated to provide support to the Judicial Conduct Committee and the Judicial Conduct Tribunals when they sit. Also, the influx of complaints received against acting judges has only aggravated the situation, as the Judicial Conduct Committee lacks jurisdiction to entertain complaints over acting judges once they finish their acting stints and go back to practice. The heads of court, as well as the Judicial Conduct Committee, however, are engaging the Legal Practice Council in this regard. The complaints processes, however, it's important to note this, are not immune to legal challenges, which unfortunately negatively impacts the speed with which complaints are finalized. Measures have been put in place to capacitate the Judicial Conduct Committee with a retired justice of the Constitutional Court and 2 retired justices of the Supreme Court of Appeal. This initiative has improved the efficiency of the Judicial Conduct Committee and has ensured that complaints are disposed of as timeously as possible. 5 judicial conduct tribunals that have been established by the Chief Justice in terms of Section 21 of the Judicial Service Commission Act during the previous, the period under review rather. And noteworthy is that of that 5, 3 have finalized their proceedings, which South Africans would have seen played out on the virtual platforms. 3 have finalized their proceedings and produced reports which are in the process of implementation, and 2 are in their final stages of their proceedings. I just want to take this opportunity to thank my colleagues in the Commission, both in the main structure that the country sees interviewing judicial candidates, the Judicial Conduct Tribunals, and the Judicial Conduct Committee for their hard work, which all takes place behind the scenes and for which they are not paid and no one sees. The JSC is committed to further enhancing its credibility as a constitutional body, enhancing the credibility and efficiency of the judicial appointment processes, and adopting a more strategic approach to identifying and recruiting a diverse and talented bench. The judiciary's role extends far beyond the courtroom, with many members actively contributing to society through a broad range of extrajudicial positions. These roles encompass leadership in judicial education, university administration, law reform bodies, community organizations, and professional associations. So these are extrajudicial contributions made by judicial officers. Many judges and magistrates serve as trustees, patrons, and members of cultural institutions, chairs and members of the Law Reform Commission. There are university chancellors, there are council members and teachers, leaders in community organizations, authors, and importantly, mentors of the next generation of lawyers and judicial officers. These engagements demonstrate the judiciary's commitment to fostering justice, education, legal development, and social cohesion beyond strictly adjudicative functions of the courtroom. This broader societal involvement enriches judicial perspectives, of course, enhances public trust, and reinforces the judiciary's foundational role in supporting democracy, human rights, and the rule of law in South Africa. It is testament to how judicial officers embody their duty not only as arbiters of legal disputes, but also as active, responsible citizens shaping a just and inclusive society. And I thank colleagues who take valuable time out of their busy, extremely busy work diaries to serve their nation in these positions. I've mentioned challenges during the period under review, but I must mention one of the significant progress measures that have taken place: the adoption of a revamped South African judiciary sexual harassment policy launched on Women's Day, this past Women's Day, 9 August 2025. This significant milestone has been a long time coming and is a result of a challenging journey of many years towards creating a workplace within the institution, the judicial institution, in which respect and dignity thrive. Recognizing that the judiciary is not exempt from experiencing and perpetrating sexual harassment, the policy ensures that systems of accountability and protection are put in place to address misconduct and create safer working environments within the court system. For many years, voices both within and outside the judiciary have called for stronger protections against sexual harassment. These calls echoed the broader societal shifts and demands in a South Africa which continues to confront the harmful legacies of inequality, exclusion, and exploitation, particularly of women and girls. The introduction of this sexual harassment policy thus marks a pivotal chapter in the history of our judicial system, a tangible, formal step that, according to both anecdotal accounts and objective evidence, acknowledges the lived realities of a number of those who work within this institution. It reflects the judiciary's evolution from a system once, and perhaps still so in some pockets, reluctant to address such matters openly, to one now proactive and transparent in its commitment to justice, not only in its rulings, but in workplace conduct. This progression resonates deeply with our constitutional values. It affirms the judiciary's unwavering commitment to the constitutional values of human dignity, equality, and justice, and to lead by example in institutional reforms. The policy, the sexual harassment policy for the judiciary, stands as a clear and unequivocal declaration that sexual harassment in any form will not be tolerated in our judicial system. It applies to all judicial officers, permanently appointed and acting, and covers all circumstances, private and public, in which the business of the judiciary is conducted. Importantly, the policy will find application in all cases of sexual harassment reported after its adoption, including those that relate to incidents that took place before its issue. Its core principles are guided by a victim-centered approach, and they include confidentiality, accountability, non-discrimination, fairness, support, and protection against victimization and retaliation to victims. The reporting system of the policy also follows a victim-sensitive approach and is characterized by ensuring that allegations are dealt with seriously, expeditiously, sensitively, and confidentially. Simultaneously with the launch of the sexual harassment policy, an interim gender desk and focal point for the reporting of sexual harassment complaints has been established, finally has been established in the private office of the Chief Justice, while the judiciary's supporting arm, the Office of the Chief Justice, assisted by the Department of Justice and Constitutional Development, work towards establishing a fully fledged gender unit in the Office of the Chief Justice, a process that is beset by financial constraints and the usual challenges, but will happen in the near future. The establishment of the interim gender desk is to ensure the immediate implementation and monitoring of the sexual harassment policy, while arrangements are being made for the more permanent, fully fledged gender unit. And the location of this interim gender desk is in this building, at the Constitutional Court in Braamfontein, Johannesburg, under the direct supervision of the Office of the Chief Justice. This signals a vital shift in how the judiciary responds to these issues, not as isolated human resources concern, but a matter of institutional integrity and judicial ethics envisaged by the Constitution and the relevant law. As required by the policy, all role players, including the gender desk, the heads of the superior and lower judiciary, the Office of the Chief Justice, the JSC, the Magistrates Commission, and the SAJ, must, within 6 months of the launch of the policy, and we are in month 3 now, submit implementation plans. The implementation plans will play a crucial role in ensuring a streamlined approach to addressing sexual harassment, outlining the practical steps and defining the roles and responsibilities of each role player. The plans will include essential aspects such as the administrative systems that will be utilized, the designated license and their duties, the training needs, resource allocation, and budget implications. In compliance with the training requirements set out in the sexual harassment policy, the SAJ has commenced a procurement process to acquire a standardized online anti-sexual harassment training course for all members of the judiciary. This is a project that will require specialized expertise to ensure that the training is meticulously tailored to the judiciary's sexual harassment policy, and it reflects the unique dynamics of a court environment. In the meantime, the SAJE has held webinars for all judicial officers in order to enhance awareness and understanding of the policy and reinforce its implementation throughout the judiciary. The webinars created a platform for honest dialogue, reflection, education, and a call to action for the judiciary as a guardian of justice. Furthermore, discussions in various individual courts are taking place amongst judicial officers and staff members to enhance the awareness building and encourage the use of strategies to prevent the occurrences of sexual harassment. These engagements have highlighted some important challenges in the implementation of the policy, which will require a collaborative effort in addressing them. And I must mention that the JSC has fully embraced this policy and for its own part, appointed a subcommittee that will deal specifically with the policy, assist the judiciary with the implementation and any niggles that might arise as it is being implemented for the first time. I must address an issue of profound significance to the very foundation of our constitutional democracy, the institutional independence of the judiciary. The transformation of the judiciary has long been a cornerstone of government efforts to fortify constitutional governance. As enshrined in Section 165, subsection 4 of our Constitution, organs of state are mandated through legislative and other measures to assist and protect the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness. Historically, as we all know, the administration of justice, including judicial governance, was directly controlled by the Minister of Justice under previous constitutions. Post-1996 democracy, following the adoption of our democratic constitution, an era of judiciary-led administration dawned, ushering in institutions such as the Judicial Service Commission, the Magistrates Commission, and the Office of the Chief Justice as a national department. This transformation aimed to de-link the judiciary from executive control, assigning the Chief Justice powers to oversee the administration of the superior courts. On 6 June 2025, as many of us would have heard by now, a historic meeting between the presidency, including key ministers and the Chief Justice-led judicial delegation, reaffirmed the shared commitment to building a stronger, more effective justice system rooted firmly in constitutional values. This engagement marked a pivotal milestone in advancing the judiciary-led court administration model and signaled the executive's in-principle agreement that reforms are necessary to realize the judiciary's long-cherished aspiration of institutional independence. The independence envisaged is multifaceted. It encompasses individual judicial independence and institutional autonomy, characterized by financial security, security of tenure, and administrative independence for judicial officers, and paramount amongst these is financial independence, enabling the judiciary to budget for, access, and manage its resources without undue interference from other arms of government. It is envisaged that the judiciary shall be empowered through a legislative framework akin to that which governs Parliament's financial management, ensuring robust governance structures and accountability mechanisms. The fine detail of the institutional model is still being negotiated, but I can mention this, that it has been agreed that the transfer of some administrative functions from the Department of Justice to the Office of the Chief Justice will occur in 2 phases, beginning with shared and retained services from 1 April 2026, just a few months away, covering facilities, management, security, court recording technology, transcription, library services and such services. A draft cabinet memorandum and skeleton bill have been prepared to operationalize full institutional independence, including establishing a unified judiciary that will finally bring the magistrates within the judiciary's fold. The cabinet has endorsed, as we are informed, progressing this legislation through the Justice Ministerial Cluster. The ongoing discussions and negotiations between the judiciary and the executive are set to provide guidance towards judicial institutional independence, an evolution indispensable for safeguarding the rule of law, reinforcing public trust, and ensuring that the judiciary fulfills its constitutional mandate unfettered by external influences. And it's incumbent on all of us as custodians of justice to embrace this transformation resolutely, for the promise of constitutionalism rests on an independent, impartial, and empowered judiciary. In closing, it is with deep concern that we acknowledge reports indicating that public confidence in the judiciary has waned, accompanied by troubling perceptions tarnishing the integrity and honor of this revered institution. Judicial officers are sometimes accused of misconduct and incompetence, claims that strike at the very heart of justice and threaten to erode trust in the rule of law. However, it is important to emphasize that the Judicial Service Commission and the Magistrates Commission respond with the utmost seriousness to charges of impropriety within judicial ranks. They do not hesitate to investigate complaints brought against judicial officers and take necessary decisive action against those found guilty, doing so as expeditiously as possible. This rigorous oversight underscores the judiciary's commitment to upholding its ethical standards, maintaining accountability, and restoring confidence in an institution fundamental to our democracy and constitutional order. The judiciary of South Africa remains steadfast in its ongoing commitment to justice, integrity, and constitutionalism. As recently reaffirmed in the media statements issued by the Office of the Chief Justice, the judiciary strives to uphold the highest standards of impartiality, independence, and respect for the rule of law, recognizing that these values are essential pillars sustaining our constitutional democracy. It cannot be overemphasized that the courts are guardians of the Constitution and that every judicial officer bears a profound responsibility to exercise their duties with integrity, ensuring that justice is administered fairly and without prejudice. This commitment extends to fostering a judicial environment that respects human dignity and equality, as evidenced by recent pioneering steps, such as the adoption and implementation of the sexual harassment policy. The judiciary's dedication to continuous improvement, enhanced accountability, and the protection of constitutional rights embodies its promise to serve the people of South Africa with fairness and excellence, ensuring the Constitution's spirit permeates every facet of justice in the land. In calling for collective action and vigilance in safeguarding judicial independence and public trust, it is imperative to remember that the Constitution places this responsibility squarely on the shoulders of every citizen. Judicial independence is not an abstract ideal, but the cornerstone of a functional democracy and the rule of law. Section 165, subsection 2 of the Constitution affirmatively states that courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. This independence ensures that justice is administered fairly and without undue influence from any person or organ of state. Therefore, the public's role in watching over the judiciary is critical, not as a source of undermining, but as constructive oversight that holds judicial officers accountable while respecting their necessary autonomy. Citizens must not hesitate to critique the judiciary where it is warranted, but should be mindful to do so constructively, recognizing that honest scrutiny strengthens rather than weakens our justice system and democracy. By embracing this balanced vigilance, we collectively preserve the integrity of the judiciary, ensuring that it continues to serve as a guardian of freedom, equality, and constitutionalism for all South Africans. I take this moment to express our collective gratitude to all who have demonstrated unwavering dedication and service to the noble cause of justice. While the Republic and her people confront profound and multifaceted challenges, South Africans have repeatedly exemplified resilience and fortitude in the face of adversity. This enduring spirit of courage fortifies our shared commitment to the grand project of building a prosperous, equitable, inclusive, and just nation, an endeavor that remains imperative and resolute. May we continue to labor steadfastly in close unity to secure the promise of our Constitution and the deep aspirations of our people. Thank you.
Yeah. Thank you very much, Chief Justice. The people of South Africa must consider themselves blessed to have a leader like you. It is clear from the report that you have just presented, in the spirit of accountability and transparency, that the judiciary is in good hands. May you continue to lead us, CJ. Can we just give a round of applause? Thank you very much. So then we're going to move to the question and answer session. Following the question and answer session, a vote of thanks will be rendered by President MP Molimela, then after which the proceedings will close. There's just one thing that I just want to bring to the attention of the members of the judiciary, that you are respectfully sensitized that this lunch, the visitors' lunch here, should be approached with an understanding that the interactions, formal or informal, are recorded at all times. So be careful of what you say in this room. So yeah, that's a point that I wanted to emphasize. Then, regarding the next item, which will be question and answers. So the guests who wish to ask question must raise their virtual hand, and I'll recognize them. And the guest will then be unmuted. Please, the question, you must try to keep your question short. There is a limited time available for the question and answer session. Accordingly, the guest should refrain from making speeches, although a sentence or two as a preface to a question would be permitted. As I indicated earlier, that the chat functionality is disabled. The guests should introduce themselves before asking questions, and then the order is going to be as follows. I will take the first 3 questions, and then I'll allow the Chief Justice to answer, or if it's a question that relates specifically to a division, the CJ will then ask the leader of that division to deal with that question. I see that there is a hand, is Ruan Nell.
Yes. Program Director, thank you very, very much. My name is Andries Nel. I'm the Deputy Minister of Justice and Constitutional Development. My greetings to the Chief Justice, Deputy Chief Justice, and the President of the SCA and the entire leadership of the judiciary and all on the platform. Seeing that this is a question and answer session, my advocacy skills are being put to the test today. But my question to the Chief Justice is, would the Chief Justice agree that the Department of Justice and Constitutional Development welcomes the release of the 2024-2025 Annual Judiciary Report, and that it appreciates her leadership of the judiciary? Furthermore, would the Chief Justice agree that the report lays a basis for ongoing engagement between the judiciary and the executive to support the work of the judiciary as we work towards the establishment of a single judiciary, and to strengthen the institutional independence of the judiciary through the establishment of a judiciary-led court administration model in order to give effect to the injunction and the values of our Constitution? Thank you very much.
Thank you. My apology, Deputy Minister. Your name on the screen was indicated as Ruan. I don't know where is that coming from. So thank you very much. Do you have another question? So there's Ruan Nell again. Ruan Nell, I don't know. Is it the same person or? All right. Is he? Sorry. Okay. Rebecca Muhlala. Can I then take the next question? Is Rebecca Muhlala, Miss Rebecca Muhlala?
Yes, thanks so much, Chairperson of the session. Let me take an opportunity and greet you and the Chief Justice. And let me just, because of the saving of time, just say protocol observed. I said my name is Honorable Rebecca Muhlala. I'm a member of the National Assembly. I serve in the Portfolio Committee of Justice and Constitutional Development. So thanks so much, Chief Justice. We appreciate the depth of the report and the transparency with which the judiciary has attempted to account. However, your own presentation paints a picture of judicial system facing profound strain, from mass retirements and the erosion of institutional memory to an explosion of complaints against judges and unprecedented delays in finalizing both cases and complaints. In that spirit, Chairperson, we raise the following question. Chief Justice, you have highlighted a significant wave of judicial retirements, particularly in KwaZulu-Natal, and the Supreme Court of Appeal, resulting in a loss of senior expertise and institutional memory. How has the Office of the Chief Justice ensured continuity in divisions where entire specialist capacities such as commercial law have thinned out? And has the OCJ conducted any risk assessment to determine whether divisions experiencing high retirement rates are also those suffering from backlogs, inconsistent judgments, or increased reliance on acting judgments? Chairperson, the other question that I want to raise, which is the second question, is about the explosion in complaints. The report shows a disturbing trend. 93 complaints in the year 2022-23, 125 complaints 2023-2024, and 132 complaints in 2024-25, with 71% now pending. This raises a structural question. Is this rise due to judicial misconduct, declining standards, public frustration, or failures in judicial oversight? And because acting judges fall outside the jurisdiction of the Judicial Conduct Committee after their term ends, what is being done to close the accountability gap so acting judges cannot escape scrutiny simply by completing their acting stint? I will end there, Chairperson. Thanks so much.
Thank you very much, MP Muthala. Can I just take the third one? Mr. Jivan. It doesn't appear on the screen. Mr. Jivan.
Thank you. Thank you, respected guests and Chief Justice. I'm a practitioner in KwaZulu-Natal, and part of the problem we're having is it addresses the question of access to justice, is the allocation of trial dates. It's becoming so tenuous, it is so tenuous to obtain a trial date that the entire process almost comes to a standstill. We can get to the stage where we issue summons quickly and promptly, we get the service of the summons promptly, but once the pleadings have closed, we are left with almost in the dark as to what the position is regarding the trial dates. In one instance, my application was even given preference where the judge made an order that the case would be given preference, a preference trial date, and still we are left in the dark as to where our case and our application lies. Now, a simple process is, if I can compare it to the deeds office, the deeds office tells us all the time that we've received your application has now been processed, and your application is due to be registered tomorrow. And on the day of registration, it tells us it's registered. And the communication, we have the facilities for communication now. The email is the greatest facilitator of communication in the world. And therefore, I think that we, as practitioners, it is almost impossible for us to satisfy our clients because we have no knowledge of where our application lies. If we can get a simple communication from the department, from the registrar telling us, your case has been received, your trial date is being assessed, and this is what we require, and thereafter your trial date has been allocated. Thank you. That will greatly facilitate our task, and I'm sure my solution will apply to the entire country, including the Labour Court.
Thank you.
Thank you,
Thank you, Mr. Chivan. All right, I'll call upon the Chief Justice to...
Thank you, DP Zondi. I'll start with the DM's input. DM Nell, I concur in both your submissions and thank the Department of Justice on behalf of the judiciary for the compliment you've paid us and for the constant support. And speaking about support, I just want to, in front of the nation, express the judiciary's appreciation for the utmost cooperation that the judiciary has received from the Department of Justice and Constitutional Development under the leadership of Minister Gubai and you during this very difficult time with a plethora of challenges for the judiciary. The department and the OCJ know the tussle we constantly have about the challenges, the vacancies in the courts, the infrastructural challenges, issues of safety for judicial, for courts, for judicial officers, and so on. The list is endless. But the executive, and personified in this instance by the Department of Justice and Constitutional Development, in this massive undertaking that faces the judiciary, the quest for its institutional independence has been there, fully supporting and cooperating to the utmost. And we appreciate that support, and we have no doubt that if things carry on as they are, the judiciary will get where it wants and become the fully independent institution envisaged in the Constitution. Now, coming to MP Mohlala's question, yes, the judiciary is facing strain on almost all fronts, MP. The superior courts in particular, struggling with the challenges I've painted when I presented the reports, with the main issue being the fact that the number of judges has remained constant for a long time, while litigation has exploded in the country, as we all see. Resources are dwindling, there are financial constraints, the equipment, the infrastructure around us is crumbling. So the judiciary is facing all those challenges. But that is what we have and what we must work with and strive, as we are doing, to improve every day. You have asked how, if the OCJ, what steps, if any, measures it has put in place to ensure that the brain drain visited upon the institution by retirement of senior experienced judges. As I mentioned during my presentation, the key measure that the judiciary, through the SAJ, has in place and is fiercely pursues is the training and education of judges. The programs which the SAJ runs, for starting with aspirant judges all the way to senior judges and everybody who falls in between, ensure that to a great extent, we continue to hone the skills of those already in the institution, applying justice from the bench, by keeping up with the developments that constantly take place in the evolving world around us. That education and training is invaluable, and it is what the OCJ has in place. And OCJ working within very severe financial constraints, but that is the fate of the entire country. We all suffer that strain, but the OCJ is doing something in that regard. You have mentioned the rising number of complaints against judicial officers, and in response to, you sort of posed the question about why we have this increase in judicial misconduct, as you called it. All I can say is that judicial officers come, there's one society, we are all members of it, we live in this one South Africa. So I suppose if things are not going well. They don't go well for all of us. But we have measures in place as the judiciary to ensure that those who are in this institution stay within the letters, the strictures of the Constitution and the law in the discharge of their functions. We have the Judicial Service Commission, we have the Magistrates Commission to deal with cases where judicial officers, go astray of what they're supposed to do. There is a challenge regarding the issue of acting judges who come to act, delay judgments, for example, or misconduct themselves in one way or the other, and then they return to practice, and then the judiciary no longer has authority to sanction them. And as I mentioned, there's a gap. There is a gap in the relevant law that needs to be addressed. But as I indicated, the judiciary, the heads of court cluster, has reached out to, it has a committee that is working together with the Legal Practice Council that does have authority over practitioners who come and act in our courts, to see how this can be addressed. And perhaps I could ask AJP Ledwaba, who is part of that process, to say a bit about that, if there's anything more you think should be said on the subject.
Thank you, Chief Justice. The question is indeed legitimate that litigants want to know as to when will their cases be finalized. And the question raised by the MP, it is indeed legitimate that there should be relevant directives which deals with this aspect. And commenting briefly on the question of AJs, I think because there was a ruling by the JCC that the acting judges, if they have left the judiciary, should go back, and if they go to their practices, they are to be handled by the LPC. That regulation needs to be changed so that the JCC can have jurisdiction on matters or on misconduct or alleged misconduct by the time when a person was acting as a judge. Thank you, Chief Justice.
Thank you, AJP. Regarding the last question from Tenny Jivan, I will ask the Deputy Chief Justice to respond.
Thank you very much, Chief Justice. I think we've heard what the issue is from the practitioner. The quickest way of resolving case flow issues such as the one you have raised is to raise these questions with the JP in the PEC. She chairs the PEC in the region, and the professional bodies are represented in the PECs. I mean, my experience as JP in Gauteng is that those representatives of the legal professions who come to the PEC meeting come with all such issues, and the PEC has proven to be a very effective case flow management structure that looks at what's happening at court level provincially and comes with informed decisions on how to improve that. So my advice or guidance is that this issue should be raised in the KZN PEC and be resolved there. Thank you very much, Chief Justice.
Thank you, DCJ. DP, do you give me permission to ask President Mulemela to say something about the loss of skills at her court, the Supreme Court of Appeal, rising from retirement and progression of colleagues?
Yes, thank you very much, Chief Justice, and thank you very much to Honorable what's her name? Rebecca, for your question relating to loss of skills, if I may put it that way, as a result of judges who are retiring. And you mentioned two courts in particular. You mentioned the KwaZulu-Natal Division of the High Court. You also mentioned the Supreme Court of Appeal. I am very happy to inform the nation that subsequent to my appointment as the President of the Supreme Court of Appeal, we held a judges meeting of all the judges of the Supreme Court of Appeal, and we did an exercise that we can call a skills audit about the skills that are required at our court. And since then, at 2 rounds of interviews, of JSC interviews, 6 very competent colleagues have been appointed, very experienced, with diverse and complementary skills. So I am satisfied that at this point in time, as I am addressing the nation, the Supreme Court of Appeal has a very competent team of justices that are waiting to dispense justice. All that we need are financial resources to make the court more efficient. Thank you, Chief Justice.
Thank you, Chief Justice. Thank you, DCJ. Thank you, AJP Lidwaba, and thank you, President Mulimela. I see the time is just against us. We've got about 10 minutes remaining. Maybe I might just take 2 or 3 more questions. But in any event, you can still send your question to the following address. It appears on the 8 memo. It's Judiciary Day 2025 at judiciary.org.za. I don't know if the address can be put on the screen into which to send the question. Do we have a question? There's a hand up, but I can't see whose hand it is. Is it a follow-up question? No. All right. Yes, MP Phala.
No, thanks so much, Chairperson. It's actually a new question, but it's relating to the questions that I asked previously. Actually, this one still delayed justice. Chairperson, I think I will raise the name because I think this was is a public issue that everyone knows about it. It was on paper. There is one of the most alarming case of retired Judge Anton van Zyl, who still have 8 late judgments, including 2 matters outstanding since 2012 and 2013, and who delivered 1 judgment 12 years after hearing the matter. Can South Africans honestly say that justice was served in those cases? And what message does it send about judicial accountability when such extreme delays occur with no visible consequences? Chief Justice, can we be assured that the Judicial Conduct Committee will finalize the complaints, or if possible, will deal with the matter of Judge Anthony van Zyl with agency and transparency? And what concrete steps will be taken to prevent judicial officers, retired or active, from keeping litigants in limbo for more than a decade? It needs to be dealt with. It cannot be allowed. Last question, Chair, is I think the other speaker spoke about it. Delayed cases till 20, some of them are delayed now till 2030 in Johannesburg, in Gauteng High Courts. Courts are being, litigants are being given cases dates until 2030. What is the Chief Justice doing about that? Because it cannot be possible. The late dates given it's, I think to me, is justice delayed, and it is causing justice to be denied at the same time. So what is the leadership sitting at the table saying to the whole entire nation about that, and how can they assist to fast track and make sure that cases are not delayed to that extent? Thank you so much,
Thank you,
Chairperson. I
MP
think
Mokhala. Two questions. There are two questions. One is related to the delayed judgments by retired Judge Van Sale, and the second one is the delay in the allocation of trial dates. Do we have more questions or sort of? Is that all? Okay.
And I've sent, sorry about that, I've sent also questions in the chats group, if possible, if you can go through them. The last one was dealing with the issue of a bail, repeat offenders given bails. Recently we saw on TV that an accused by the name of Katisi Molefe was given 400,000 bail after he was given 100,000 bail. How does that happen? Can the leadership please respond on that? Because the country have put all the trust on us.
Thank you. So yeah, you have three questions: delayed judgment by retired Judge Van Sale, and delay in the allocation of trial dates, and now the granting of bail to repeat offenders. Over to you, CJ.
Thank you, Program Director. On the first question, MP Moshala, all I will say is that the fact that a judge has retired does not insulate that judge from misconduct proceedings against him or her. In the case of Judge Van Sale, the case you cite, the JSC has dealt with that matter. And the JSC does deal with matters involving retired judges, and even recommending their impeachment while they are retired. So the long arm of the law reaches a judge who has misconducted themselves into the nest of retirement. The second question, I'm sorry, what was the second question? It related to the what the leadership, the judicial leadership intends.
What are you doing about it?
Doing about it. This is an endemic issue in the High Court that has actually landed one division and its head in the courtroom when that head tried to put measures in place to alleviate this issue raised, MP. And I'm going to ask DCJ Mlambo, who happens to be that head, to speak on, on this issue.
Thank you very much, Chief Justice. Indeed, this is a legitimate concern that trial dates are delayed. The Chief Justice, in her delivery, covered the fact that there's an explosion of cases that the Superior Court has experienced. That explosion has not been met by an increase in judicial capacity to deal with that caseload. And that's why dates are given more and more into the future, because judges are human. They can deal with as much and not more. Now, the issue the Chief Justice mentions is in Gauteng, the leadership issued a directive that almost 80% of the matters that land on the trial date are matters that could be resolved easily through mediation. And that mediation directive is currently being applied. And those dates from 2030 to 2031 have all been taken away and parties are redirected to mediation. The AJP who is here, who has experienced how that mediation initiative has proceeded, can give further detail. But as I sit here, I know that there are no dates as we speak that are being allocated in 2030, 2029, 2031. So that was one initiative that the leadership of the division took, because the leadership was aware that the justice denied is actually justice delayed, or justice delayed is justice denied, as you put it. So I think that's my answer. But on a broader question, I know that the Law Reform Commission is in the process of finalizing a mediation bill that will cover most of these matters that are clogging the court's roles. And that has to be welcomed, because there are other jurisdictions. I mean, Kenya, Nigeria, to name two, have got a multi-door litigation policy in terms of which matters are entertained by the judiciary through this multi-door system. And it has assisted in reducing backlog in trial dates. So we look forward to the Law Reform Commission coming up with the mediation bill, which could become an act, and that will redirect matters away from courts to mediation and other alternative forms of resolving them. CJ, I may leave it there. Thank you very much.
So, Acting JP Ledwaba, there's something that PCJ mentioned, and in which you can offer some assistance.
Thank you very much, CJ. The question of days being allocated to 2030, also the leadership identified that matters that were not trial ready were allocated dates. And when those dates were allocated, come the date of hearing, those matters were postponed again, because the parties, or some of the parties, were not ready to proceed with those matters. However, the good news is that with a new directive that has now been issued, we guarantee the parties that if all the requirements have been complied with, if all the efforts have been taken by the parties to make the matter trial ready, a date would be allocated within 18 months. So that should be good news to the litigants who comply with all the requirements. They know that they'll be allocated dates within 18 months. And the other aspect that I wanted to mention in respect of the question is that we also had the default judgments applications that were set down to 2013. Steps have been taken that all those matters which were postponed to those days would be dealt with during the course of next year. And I might also just mention that we are thankful to the Department of Justice in allowing that we should have about 15 extra acting judges who would assist us to deal with that backlog. So at the moment, as we speak in Gauteng, we don't have matters that would be heard in 2020, 2030 or 2031. All those matters, as I've said, would be dealt with, I can confidently say so, within the next 2 years. Thank you, CJ.
Thank you, AJP Ledwaba. CJ, over to you.
Before I answer, I respond to the bail issue. JP Mphahlele wants to say something on the mediation issue.
Okay. Yes, JP Mphahlele.
Confirmation about the concern of the public about the delayed justice on the allocation of dates. As the DCJ mentioned earlier, we deal with these issues in the PEC, and one would encourage stakeholders to attend PEC. And again, the different courts, like in our court, we apply strictly the judicial case management conferences to make sure that only matters that are ready to be heard are allocated dates. Thank you.
Thank you, JP Mphahlele. CJ, on the bail, on the grant of bail to repeated offenders.
Thank you, Program Director. There is a competent legal framework that governs the grant of bail to ensure that offenders or accused individuals who do not belong in the public space are not granted bail. The matters which MP Mushlala, refers to, we have also heard of them, but one would not want to say anything about something they have no full information about. One would have to interrogate what had actually happened there fully. But this is not the first time a concern is raised about bail being granted to people who supposedly should not have been granted bail. We've had communities complain about offenders who commit a crime, they are arrested today, then tomorrow they are back among the community. And this is something that it needs attention. If it means education and training, the judicial officers perhaps do not need guidance on how to apply the law, which is most concerning. And in cases where it's not just ineptitudeness that has led to that, maybe there are improper motives, then the law must take its course. But the judiciary and us as the leadership have to look into this matter rigorously and just ascertain exactly what is going on and put measures in place to address it. DCJ, I don't know if there's anything you want to say.
No, I think, CJ, you've covered it. I think the presumption of innocence is a principle that all judicial officers apply. And you are correct that if there's something amiss that's happening, as a leadership, we need to look at it. But the problem around this issue, CJ, is that very isolated incidents get mentioned and then they taint the whole judiciary. I think we should guard against that. But in general, if there's a general trend that many people who are supposed not to get bail are identified from a particular court or magistrate's court, then that should be raised as a red flag. And as the CJ says, we will look at it and seek to understand why is that trend happening. But I sit here with the confidence that when judicial officers are faced with bail applications, they apply the law. They are guided by what the legal principles are and what the circumstances of each case are, and then take the appropriate decision. But as the CJ says, if there are aberrations here and there that lead to large-scale bail being granted to people who do not deserve it, that we are prepared to look at and correct it. Thank you, CJ.
Thank you, CJ. Okay. All right, I just want to assure the members of the public that the judiciary is in the correct hands. We take full responsibility of what is happening, and we are accountable and we are transparent. So these are the principles that are guiding us in the discharge of our duties. So if there are, the chat room's questions will be responded to in writing if there are any. And I just wish to take this opportunity to thank everybody. I will now give President Molimela just to give us a vote of thanks. Over to you, my sister. Thank you.
Thank you very much, Program Director, my brother, Deputy President Zondi. May I, with your permission and the permission of the Chief Justice, stand on the protocol that has already been aptly observed by the first speaker, the DCJ. Chief Justice, it is an honor for me to deliver the vote of thanks following the presentation of the 2 annual judiciary reports. We express our deep appreciation for the comprehensive and insightful report you have presented today, CJ. Your articulation of the achievements, challenges, and ongoing priorities of the judiciary has not only informed us, but has reaffirmed our shared commitment to strengthening the administration of justice. The clarity with which you have outlined the progress made, as well as the areas that demand our continued focus, loudly attesting to the assistance and protection that the courts should receive from organs of state as envisaged in Section 165, subsection 4 of the Constitution, provides a clear roadmap for the work that lies ahead. We also extend our gratitude to all the judicial officers, court administrators, researchers, and every member of the support staff whose daily dedication gives life to the goals reflected in the reports that you presented today. The improvements noted, whether in case finalization, efficiency measures, innovation, or access to justice, despite the challenges the entire judiciary faced, are the result of the collective effort of individuals who serve with integrity and purpose. We would be failing in our duty if we failed to acknowledge the ongoing committee of branches of state, and we have to express deep gratitude for the support the judiciary continues to receive from the Minister of Justice, the Honorable Mamuloko Kubai, and the Honorable Deputy Minister, Mr. Andreas Nell, as well as the Minister of Finance. Your willingness to give us an audience when requested to do so does not go unnoticed. Our sincere thanks goes to all the leadership teams and committees whose governance and guidance have shaped the initiatives highlighted today. Your collaboration, ladies and gentlemen, with stakeholders across government, civil society, the legal profession, and communities continues to ensure that the judiciary remains responsive, credible, and rooted in constitutional values. To our guests, partners, and colleagues present today, thank you for your ongoing support and engagement. Your presence underscores the shared responsibility we all hold in safeguarding the justice system and ensuring its accessibility, efficiency, and fairness. Chief Justice, once again, thank you for your steady leadership, your vision, and your unwavering commitment to judicial excellence. Indeed, as the Deputy President mentioned, the judiciary is in very good hands. The reports we have received today reflect not only institutional progress, but also your personal dedication to strengthening the rule of law in our country. With that, we close this session with appreciation and renewed resolve to continue the important work before us. I thank you.
For 25 minutes, as we already are running behind time. However, as we do that, I must just ask that we also note that questions must be concise, straight to the point. And the second issue is that, and quite importantly, that Should we run over time or out of time, questions will then be dealt with in writing. For the sake of process, we will take 3 questions at a go, and based or depending on how much time we have left, we will entertain or allow more questions. But safe to say that the big peg right now is to keep to the 25 minutes. With those words, I have now opened the session, and I ask that people who are speaking or asking questions, please straight to the point, introduce yourself, as well as the media house that you represent. Ngiyabonga. Sawubona Mbekezeli Benjamin. Yours is the first question, please. Go ahead.
Thank you very much, Ms. Gambo. Thank you very much, Chief Justice, and to the justices present. Good afternoon. I have 3 questions. One is for you, Chief Justice. One is for Justice Mulemela, and the other is for Judge President Mulahlei. I'll ask them quickly. So the first one, Chief Justice, concerns the performance of the Constitutional Court. It's the first time I've seen in the last maybe 5 years that the Constitutional Court has exceeded its target of 70%, which is great. But the concern, the question is, what steps can you attribute this performance to? What initiatives? Because I do recall there were some initiatives that were taken to manage the caseload of the Constitutional Court. The second question for Justice Mulemela, the performance of the Supreme Court of Appeal has unfortunately not met its target, which is also the first time in, I think, the 5 years of the reports that I've seen. And the cause of this is relating to the researchers that were not available. So the question is, what is the ideal number of researchers that are required by the Supreme Court of Appeal? And secondly, what has been the response from Treasury regarding the increasing the number of researchers? And also, you've answered the question earlier in the earlier session, but also I'd like your question about how do you manage the capacity of the court, because unfortunately the SCA is one of those courts where judges move pretty quickly, either promoted to the Constitutional Court or they go on retirement. What is the strategy going forward in terms of managing the capacity of the court? And the last question...
Mr. Benjamin, I think you have already asked about 5 questions. If I may ask that we pause for now. You have already covered the 3 that we had planned to take for the first round, and allow the panel to take those. And then only after Ms. Hunter, can you please come back? Please hold on to that question. And I now hand over to the panel. Thank you very much.
Shall I have first bite? Okay. Thank you for that question, Mr. Benjamin. Maybe let me just start by saying that the Constitutional Court justices have always worked extremely hard. You mentioned that in a period of about 5 years, the court has managed to climb above its own set target. I doubt very much that the problem previously was that the judges did not apply themselves with as much vigor and energy as they do now. I'm not entirely sure what the magic bullet has been. Well, I'm exaggerating. It's not a magic bullet. We climbed just 1% over the 70%. We still have 29% to cover to get to 100%. But the court has just continued to work as hard as it has always done. With the structural challenges that it has, with the the overwhelming amount of work that comes through this court, especially in the form of applications for leave to appeal. And strangely, the numbers of the statistics, the numbers of the cases that continue to come to the court are increasing, they're not decreasing. So maybe there's something we are doing to work smarter. What it is, I'm not sure, you know. But it has been quite encouraging for the court to finally manage to climb over its own set target. And in addition to whatever it is that the court is doing, there are steps that the court is devising, trying to put in place to ensure that work, you know, flows smoother in the court to the point where the ultimate goal is to get judgments delivered expeditiously, and that's the target. So there are measures that we have in mind, the chief of those being a constitutional amendment that will allow the court to dispose of certain matters in smaller panels, in essence function in the same way as the SCA is doing, is sitting in smaller panels, especially to deal with what is ordinarily called petitions in cases that are not as complex, not as important. We're not saying that not all matters that come through the court are not important, but there are cases that are more complex and demanding than others, which could be dealt with, you know, by a smaller number of judges in conjunction with the rest of the court as well. So that constitutional amendment, I'm happy to announce that it is in progress. Motivation was submitted to the Department of Justice, which would be our, you know, they hold the key. And the State Law Advisor, the State Law Advisor's office is working on those. And there is another measure that we have in mind, which is employed by all other apex courts in the free world, having a body of experienced lawyers. There are countries that have as many, there's Canada, which has as many as 22 for 9 judges, 22 senior lawyers helping with, especially with the sifting, because that's the nub of the problem in our court. All these applications that come through, some of them with no merit, unfortunately, but they require that each justice still goes through them, each of the 11 justices, and that is time consuming. So we have been promised one of the measures we have been, measures to capacitate the court as the rest of the judiciary with the executive, particularly the Department of Justice. The employment of 6 such lawyers has been guaranteed. The funds will be made available from 1 April 2026, so that is heartening. We are 11 judges. Ideally, we would want to see maybe 3 times that number or even more, but we will take what we can get. And that will surely ease the strictures in the workflow of the court. So I hope I've answered your question in my long-winded way, but that's where we are. And the court continues to work as hard as it has always done so, even if the results may not always be what is expected. Thank you, the Program Director.
Thank you, Chief Justice.
Thank you. Thank you very much, Mr. Benjamin, for your question. It's a valid question. And I think I must preface my response by saying that it is my duty as the leader of the Supreme Court of Appeal to ensure that the morale of my colleagues remains high. And the reason being, we work very, very hard at that court. We don't know what the meaning of recess is. We don't have any recess. We have conferences during the recess. We read for our appeals. Our appeals are finalized relatively quicker. And the workload of that court as an appellate court is the highest in South Africa. And that court has been performing very well. And as a person who's very keen on sport, I know that there's a saying that you must nurture the skilled player. If you are a coach, nurture the skilled player so that the skilled player can continue to excel, and when he excels, the rest of the team get inspired and they excel. And that is what was supposed to happen in relation to the Supreme Court of Appeal, as the court that has consistently performed very, very well over the years. Red flags were raised by the Chief Justice herself at her interview. I think it was her 2022 interview, where she bemoaned the staffing of personnel at the Supreme Court of Appeal. At my interview in April 2023, I lamented the same thing, that we don't have enough support staff, especially in relation to the research capacity of the court. Now, I've just said in response to MP Mohlala's question that the Supreme Court of Appeal has appointed 6 very competent judges and said that we have a complement of very competent judges, and I repeat that. But, you know, there's only so much that judges can do. We do rely on support staff, in particular, the registry section, as well as the research component of the court for purposes of our efficiency. If I can make an analogy, a plane is flown by pilots, but the pilots won't run the airline efficiently. They depend on ground staff as well. For those pilots, for that plane to remain on air, they rely on the cooperation of the ground personnel, the air traffic controllers, and so forth. And it works like that exactly in the judiciary. And Mr. Benjamin, you asked me about the ideal number of law researchers at the Supreme Court of Appeal. We have a complement of 26 judges. Now, based on what is happening at the Constitutional Court, which is a court of appeal, like the Supreme Court of Appeal, the number of researchers supporting the judges is unfortunately disproportionate. At the Constitutional Court, every judge is assisted by 2 law researchers, and based on my experience when I was acting at the Constitutional Court, I know that the Chief Justice and the Deputy Justice, each one of them, were being supported by no less than 3 law researchers. If you have a look at the Superior Courts Act, Section 13 and Section 17 read together, you will see that only the most complex of appeals should be handled at the Supreme Court of Appeal. And in most instances, that is what is happening. But because it is a court of appeal, first of all, we don't discuss our cases beforehand. We keep an open mind until the date of the hearing. And after the hearing, we hold conferences to persuade one another, and we then start writing the judgment. But that judgment has to go through a pair of 5 eyes, and that takes time. And that's why the role played by the law researchers is so important in terms of editing our judgments and site checking and all of that. But unfortunately, the Supreme Court of Appeal was strangled so badly that at some point 26 judges were relying on 3 law researchers. And I had made several pleas to the former Chief Justice about increasing the number of law researchers at the Supreme Court of Appeal. I know that he did his bit. He contacted the SG of the time, and unfortunately, we could not get it right. And soon thereafter, there was Circular 49 of the DPSA, Department of Public Service and Administration, which introduced austerity measures. If you read that directive, it said that the judiciary was exempted. But in effect, that did not happen. What happened is that for every single post that was vacated, the filling of that post was suspended. It killed the court. And we had an opportunity to have, and the Chief Justice has already alluded to this, that there was a delegation of the judiciary that met with the president of the country and members of the executive. I was part of that delegation, and I, together with all the other justices who represented the judiciary there, we all made presentations. And in my presentation, I did allude to the fact that the Supreme Court of Appeal has a hopelessly inadequate number of law researchers, and that it's impeding our work. So what the Chief Justice alluded to in her interview in 2022 about the staffing was bound to manifest itself at some stage, and it did. It did, and unfortunately, that has now affected the performance of the court. To our credit, we have met our targets in relation to reserved judgments, and we have performed very, very well in respect of the applications. We have far exceeded our target by achieving 93 instead of 80, so we are doing very, very well. In relation to a dip in the finalization of appeals, I need to point out a few things. That if you have a look at the annual judiciary report, you will see that steadily the number of applications handled by the Supreme Court of Appeal have been increasing over the years. The number of judges has remained the same. So the same judge resource that considers the applications where we are excelling is the same pairs of eyes that are going to read the appeal records and thereafter prepare a judgment. So it was bound to have an impact. Our workload in terms of applications has increased multiple fold. And remember now that these applications are petitions, and by their nature, they are urgent. So regardless of what you were doing, if you were preparing a judgment and a petition lands on your desk, you stop doing whatever you were doing and you consider the petition. And so I think I'm very proud of the fact that we have performed very, very well regarding that extremely urgent area of the work. And I mentioned the meeting with the president and the other members of the judiciary, and I'm very happy to mention that at that meeting, the Minister of Finance was present, and after hearing the presentation that the judiciary made, he immediately gave a commitment that the judiciary would appoint 7 more law researchers. 7 more law researchers have been appointed. It takes our staff complement to 13 law researchers against 26 judges. So going back to your question, Mr. Benjamin, where you asked what is the ideal number, now I will say to you, I have already said that the Constitutional Court, each 2 researchers, sorry, 1 judge is served by 2 researchers. We acknowledge that they are the apex court. We are not asking for that, but at the bare minimum, a judge should be having a researcher allocated to them, which would mean 26, and at the moment we are 50%. But we continue to do our best, as we have been doing all along, and I'm quite certain that with the additional number of researchers that have been appointed, there is going to be a marked improvement in the performance of the court. And I want to conclude by mentioning that if you look at the 2019-2020 annual judiciary report, you will see that the former Chief Justice, who was the Chief Justice at the time, Chief Justice Mogoeng, now retired Chief Justice Mogoeng said that the setting of performance targets is very much aligned to the amount of resources that are given to the judiciary. if you give the judiciary X amount of resources and you keep lowering them, then what should be happening is that we should also be saying, no, we are reducing our targets because the resources are being reduced, but we don't do that. We still try hard to achieve the same targets with less resources. Less resources in terms of human capital, less resources in terms of library resources. It's a challenge. But like I have said, I am quite certain that there is going to be a marked improvement. If we were to get 13 more, we would be very grateful, but we are also realistic because we were informed that unfortunately there's no funding for that. So we will be patient, but we want to take the nation on board so that they understand our plight, that we have had serious challenges. In the main, we managed to surmount those challenges. And I think I will leave it at that for now. Thank you.
Thank you, President. Ray, good afternoon. Please ask your question, and like we said earlier, we are now fast approaching.
Good afternoon, ma'am, and good afternoon to you.
Hold on, please, Ray. Please, hold on, please.
Sorry, I was just under the assumption that I was next, but I'll wait my turn.
Ms. Hunter, you are definitely on the line. We will come back to you. We just need to address the last question that was raised by Mr. Benjamin. Thank you.
Sure.
Justice Mlahle, you are on the platform, and may we please have your answer in relation to the question that was raised by Mr. Benjamin? Thank you.
Good afternoon. Can you hear me?
Yes, we can. Thank you very much. You can go ahead.
I actually was cut off the platform when the question was asked. Would you mind giving me the question again?
Mr. Benjamin, I'm going to give you a couple of seconds to just summarize your questions so that we still have more time for other questions. Thank you very much, Mr. Benjamin. You can speak.
Thank you, Ms. Kambo. In 10 seconds, Judge Mulahle, in the Joburg Labour Court, there are 7 times as many as the Gqeberha Labour Court, and the judges of the Labour Court seem to be constant, which causes why the court is a bit under strain. But every time you advertise for vacancies, there doesn't seem to be candidates who come forward for appointment to the Labour Court. So the question is, what is the strategy going forward to address the judicial vacancy in the Labour Court? And also, what is the strategy to increase the number of judges in the Labour Court? And especially considering that the report tells us that there is a decline in cases, in terms, it says 25% decline in Joburg, 15% in Cape Town, 15% in Gqeberha. So what is the strategy going forward? Thank you.
Thank you.
Thank you very much. Thank you, Mr. Benjamin. In relation to the recruitment, yes, indeed, on the 2 rounds that we did, we couldn't achieve the number of posts that we had advertised. So the last round we met and I discussed with my colleagues as to what is the best strategy. We've now decided that we will try and ensure that when we invite people to come and act, we also just test as to their commitment in the long term. In other words, whether there are people that would be interested in joining the judiciary. And in that way, we believe it will assist us so that when we advertise, at least we know that these are people that have expressed an interest in joining the judiciary permanently. In terms of the judges, yes, indeed, we're running short of judges. The last time we had an increase, I think it was 2023, and I've written to the minister requesting that they give us an addition of, and that's a minimum, 5, for us to be able to fill in the gaps that's created by the shortage of judges?
Thank you very
Thank you.
much.
I hope I've answered the question, yes.
Thank you very much, JP. We will now take Ms. Hunter. Please ask your question. Thank you.
Thank you very much. I'll be very quick. Thank you, Chief Justice, and all the other justices present. My name is Monica Hunter. I'm representing Newsroom Africa. Now, the question is around the political commentary of the delay in the Phala Phala judgment. The EFF is a party to this matter at the Constitutional Court. The matter was heard in November last year, and then, it takes a year. So I've listened very closely to what has been said around what causes these delays, lack of resources, lack of funding, etc. But is there a definitive message to the public in relation to this case primarily, but other cases as well, that there's nothing untoward happening, and these are the definitive reasons why there was a delay in this case? Thank you.
Thank you. Ray, good afternoon. You may ask your question.
Good afternoon, and good afternoon, Chief Justice and the colleague justices. I just very quickly, I will also forward my questions in writing if we don't cover them here. As far as I heard, you have not said anything, Chief Justice, about the rationalization process, which you appreciate is very important for us in the Eastern Cape. What is the update on that? What is the latest that we can expect some movement in changes to the court boundaries? And then also just very quickly, the October JSC interviews dealt in some detail with what was termed the state of shambles in the Mthatha High Court, and specifically questions were asked about the allegations of corruption as reported by the SA Accountability Journalism Project in Daily Maverick in May this year. You're on record as saying you have issues with part of the report, but what was the outcome of any investigation that the OCJ has taken in respect of the allegations of corruption in Mthatha? Have there been any disciplinary steps against any official? Have any criminal charges been laid against anybody arising from the investigation? Thank you.
Thank you, Ray. The next question is coming online, and it is from Linda Ansel, and she would like to know what is being done to address the long delays lasting several years for the Gauteng, which is the Gauteng High Court, to hear cases. And that's from the Business Day. Thank you. That will conclude this round of questions. Yes, ma'am.
Thank you, Program Director. Ms. Hunter, your question about the Phala Phala judgment, I already spoke on that in my main presentation and explained, admitted the late delivery of judgments in the Apex Court, including other judgments that came from 2024, some even before this one was heard. And as I indicated, nothing weighs more heavily with the judiciary than when it is not able to carry out its mandate effectively, and its core mandate is delivering judgments expeditiously. So all efforts are being made to deliver judgments expeditiously. The fact that judgments are delivered late does not mean that judges are not working. They are working hard, but because of all these other issues I mentioned cause the delays. There are only so many hours in a day. There are only so many judges to do the job, and I can go on and on. But that is not an excuse. We should be in a position to get work out as soon as is reasonably demanded. But all I can say is that efforts being made to deliver that and other judgments still are outstanding as expeditiously as possible. And there is no sinister reason for delaying the judgment. It is just delayed, as have been the others. It is that. I wish I could give you a better answer, but that is what it is. The judgment will come out as soon as possible. Then there was another, I will leave the question of rationalization to the chairperson of Jacques or Jacques, who would handle that, but Jacques. I'll leave that to President Molemela, but I might as well take, is Jacques? Okay, I'll give it to the DCJ to answer. About the dire situation in the Mthatha High Court, it is a source of great consternation and concern for the judiciary, and you will recall that a while back, short while, not so long ago, I paid the court a visit to see for myself, hear from the people on the ground exactly what is going on there. And what I can say is that the little I can say without jeopardizing the processes that I play to root out the corruption is that the matter is with the police. The Hawks investigations are in progress, lifestyle audits are being conducted, and all sorts of other measures being put in place to ensure that whatever is going on, untoward that is going on there is uprooted. In addition, and the OCJ, when I went down there, the OCJ did establish an implementation plan, just to unclog the blockages in the operations of the court. And I have, unfortunately, during the past JSC interviews, had accounts from the candidates who were vying for the position of Deputy Judge President in one of the seats of that division, that actually things seem not to have improved at all, despite these measures that the Office of the Chief Justice sought to put in place. So what I have done, as yet another layer of the effort to clean up that court and just get things working as seamlessly as they used to go when people such as myself and Justice Matlanga and other colleagues of ours still worked there, back in place. I have appointed a committee headed by the Deputy Chief Justice to assist the acting Judge President in the court in identifying where things are as we currently stand, and come up with suggestions on how we can sort things out down there. And I am happy, perhaps when he gets his chance to speak, he'll tell us a bit about what, the initial steps that he has taken to start this process. There is a process that has been kickstarted already, and it is promising. It is promising. No doubt about it. We will get Mthatha working as good as the other seats in the division, but it's going to take a bit of time. And one does not want to raise excuses. The fact that the instability, the fact that there is no permanent head of the court has somewhat impacted the operations, not just in that seat, but in the entire division. But the situation is where it is. We do not have a permanent head of court in place. There are processes in place, and we just have to wait until those processes run their course. But in the meantime, steps are being taken, measures are being put in place to ensure that the division works as optimally as it should. I will hand over to DCJ to speak on where the rationalization, the Museneke report process is.
Thank you very much, Chief Justice. In terms of the Mthatha issue, I confirm that there have been preliminary discussions between myself and AJP Tlangulela, and out of that conversation, I can say with confidence that there's light, a big light, at the end of the tunnel. But the process is still ongoing, and hopefully by the end of January, we will have come with some firm conclusion as to how things are taken forward in terms of stabilizing what's happening in the division. So that's as much as I can say about Mthatha. About the rationalization process, what may not be known out there is when the initial recommendations were released by former DCJ Museneke. I was one of the judges president who commissioned a meeting with retired DCJ Museneke and went through the recommendations, the interim recommendations or suggested recommendations. And we went through them one by one. And some of them have got far-reaching effect. And because of that, DCJ Museneke had us and undertook to go back to the drawing board. But he came back with the final report where there had been no movement to the issues, especially the issues of concern that as judges present we raised, we wanted those recommendations to be changed. So his final report is out. It sat with the ministry for some time, but the minister released it to the JSC and it came to the heads of courts. The heads of courts have looked at it and they are, when I say heads of courts, I mean the heads of the high courts, because that report doesn't affect the Supreme Court of Appeal or the Constitutional Court. It was more directed to the high courts. So the heads of courts have undertaken to continue the discussion with the minister because it lies with the minister to implement the recommendations of that report because it is her office that commissioned the investigation in the first place. But what I can tell you now is in the last heads of courts meeting, there was an agreement between the minister and the heads of the high courts that there would be an engagement where they were going to go through each of those problematic recommendations and then a way forward will come out. So I will not be involved in that process because I'm no longer in the High Court, but the heads of the High Courts are going to be dealing with that matter going forward. Thank you, CJ.
Thank you very much, Deputy Chief Justice. Thank you very much to all the panel members. Mr. Benjamin, are you still online? Yeah, of course you are.
Yes.
Please give us your, your last question, please, and in a couple of seconds. Ngiyabonga.
This one will be very short. Chief Justice, you presented 2 annual reports today, which means that there was a report that was not presented, I suppose, last year. And this raises a question about transparency and accountability. Should we be concerned that the judiciary can dispense with accountability at certain times? And is this likely to go ahead? Is there any chance that the 2026 report will be delayed? And that is true also. The concern also relates to rulings by the Judicial Conduct Committee. They are not consistently released on the website. At the moment, there's only rulings from 2023 up to 2025, and those are not released on a consistent basis. So there are questions about accountability and transparency. And so could you assure us that this is not something we should worry about? Thank you.
Thank you, Mr. Benjamin. Ray?
Thank you very much. My question is in a sense a follow-up to Mr. Benjamin's question because it relates to the sexual harassment policy. Chief Justice, when we previously spoke in Bisho in 2023, you had prepared a draft sexual harassment policy. It was sitting on the desk of the then Chief Justice. When the then Chief Justice retired last year, on the last day of him being in office, he issued an instruction to the staff in his private office to send me a signed copy of a sexual harassment policy. I don't know, I've never known what the status is of that document, and I wonder if in fact it was just dumped in the refuse bin. A year later, a year into your tenure, you release another sexual harassment policy in August. I've looked at the 2 documents and they're pretty much the same, similar documents. But again, for me, it raises an issue of transparency and accountability. Was the former Chief Justice on a mission of his own just in releasing that document? What was the status of the document? Was it withdrawn? Can you just comment on those issues? Thank you very much.
Thank you, Ray. The last question is again from Ms. Enzo, and she would like to know the nature of complaints against judges, please. And thank you, and I will hand back over to the panel to give us a response. May we please just, thank you.
Okay. Was there a question from Ms. Hunter?
From?
Ms. Hunter, the other journalist?
Yes.
What was
Linda.
the question?
Linda was looking at the nature of complaints that are being lodged against judges, Chief Justice.
Okay.
Thank you.
Thank you, Program Director. Mr. Benjamin, shortly, I will just say the judiciary will endeavor that something like what has just happened during this 2-year period will not happen again, that we skip a year without accounting. Unfortunately, it's not for, there was no intention not to account. It is just that the awkwardness of the timing of the former Chief Justice's retirement, which was towards the end of the year, and my coming in as a new incumbent, just did not give us enough time to, to work on a proper report. I started in this office on 1 September. It was already towards the end of the year, and there just was not enough time to catch up with what had happened in the previous, in the preceding financial year. So a decision, after a lot of hard searching and tough debates, the Judicial Accountability Committee, our Judicial Accountability Committee, decided to advise that we postpone the reporting for the other financial year to this year and just combine the two. And we do tender our most profuse apology to the nation for that. We are always trying to better our systems and operations, Mr. Benjamin. You will recall, I'm not saying that this gives us, a free pass not to do what we are constitutionally expected to do. You will recall that the JSC previously never delivered annual reports, and from last year, the JSC has started doing what it's expected to do statutorily. And the rulings that are late, we are constantly trying to better our systems and monitoring our operations and implementing improvements. So these niggles, I can assure you, with the full backing of my colleagues, the heads of court and the entire judiciary, that we are constantly striving to better our systems. And as my youngest son usually says, we promise to do better. We will get things right. But it will not happen, at least not on my watch, that there is a year goes past without the judiciary accounting. Mr. Hatu, about the sexual harassment, the previous sexual harassment policy, I can mention that there was no skullduggery, around what happened with the first one. In fact, former Chief Justice Zondo had commissioned a committee led by me to come up with a sexual harassment policy last year. But the process was rushed, and unfortunately there was no consultation with the constituency, the people, in respect of whom the policy is meant to operate, the judiciary. So when it was published, there had been no consultation at all, and it required a lot of work. It still required a lot of work, which has gone. If you've carefully looked at this one I called revamped in my main address, you will see that there is a lot of measures, and the whole tenure of making it victim-centered, among other features that make it, functional, that have been added. So what happened? That policy, the first one, was issued. But when I came in, I realized that there had been comments from interested parties complaining about it, including judicial officers themselves who didn't know about it. So I had to withdraw it, and we went back to the drawing board. And this year, you mentioned, has been a long, hard year. We worked extremely hard on this document that we finally come up with, and we made sure that we had 3 rounds of consultation with the judicial officers, magistrates, and judges, each and every one, to ensure that when we finally produced a document, it had the buy-in of everyone. We will not struggle to implement it. And I would want to believe that that is what we have on the table as we speak. So in a nutshell, that is it. We have a revamped sexual harassment policy. And perhaps I should just take this opportunity to thank the various stakeholders who assisted the judiciary in making this document a possibility. It took a lot of work and a lot of hands, including Mr. Benjamin's institution, the DGRU, who assisted us, and academics. We got sexual harassment practitioners to assist the judges and other experts as well. So that is a social compact, a product of the work of interested persons in the country. It's not just a product of the judiciary. Everyone was supposed to have a word, a hand in it, participated in its production, and we hope that it's going to achieve what we wanted to achieve, and indications that it's going to. It's going to. Thank you, Program Director.
Thank you very much, Chief Justice. Just that last question, or the one that we started with from Linda, about the nature of complaints, if we can just
can you have her repeat it?
So she was asking if we could just comment on the nature of complaints that are being lodged against judges.
What exactly does she want? Does she want to know what the nature of complaints are that are lodged against judges? It is. This material is contained in the latest JS's annual report. It does give a brief description of the general nature of complaints that are brought against judges. But the most important one, the most pressing one, is the delay of judgments. For the better part, people, complainants, are disgruntled about the results of judgments delivered against them, and those, of course, are dealt with in terms of the Act, and they are dismissed. And there have been, I'm just trying to think, there have been complaints alleging misconduct in one form or the other. The one that is premier in my head now is one that was just raised with me in a certain context in the last few days, where a complaint was brought against a head of court who had said in a matter in which he had been involved as a practitioner in his previous life. And the JCC dealt with the matter, of course, and gave its ruling. And there's contention. It's an area of concern, actually. There's contention about the results of that complaint, which the JCC, I must highlight, dealt with expeditiously. That it was found that the judge had breached the Code of Judicial Conduct and the Constitution itself, because clearly should have recused himself in the matter. But unfortunately, there's a gap in the Judicial Service Commission Act. It does not provide an adequate sanction for that kind of transgression. First, there's a lacuna because of the manner in which the relevant provisions are couched. the judge cannot be found guilty of gross misconduct, because were that the case, then the matter would go to a judicial conduct tribunal, and the, you know, the usual processes would take place and an adequate sanction imposed. So here the Judicial Conduct Committee is hence were, so to speak, tied, and they could only recommend a sanction of a reprimand, an apology, and there's unhappiness about that. So that's something we have to look into and see if maybe there's a need to seek statutory amendments to fill this lacuna. I digress. It's those kinds of complaints, Ms. Hunter, and you'll get some that do not make sense on occasion, have nothing at all to do with what the relevant act actually allows. So I hope that answers the question.
It does. Thank you very much. I would also like to take this opportunity to thank Ausimpo and her colleague, who are our sign language interpreters, who have carried this session for us, for those of our audiences with special needs. Thank you very much, ladies. And thank you very much to all the members of the media that have made time to engage with the panelists or the panel members, but also to thank the team that has put this together, because it is a representation of what happens when the judiciary acknowledges but also embraces technology. We do not always have to meet in person. We can do things this way. And with those words, ngibonga kakhulu, I declare the session closed.